Good evening to all my dear participants. I hope I'm audible to everyone. In case if anyone has any questions or if you feel at any minute that I am probably my voice is breaking or if you're unable to see my presentation, please put it in the chat box and we'll address that then. Right, with that, I welcome all of you to this wonderful webinar that has been organized by Taxmann, and I really commend the organizers of the same for this very interesting topic that I have received, which is the SEBI insider trading regulations. And without any further ado, I would like to take all of you to the definition section. Like how all of us know that any kind of a regulation that begins, firstly, we need to understand what is the objective, the purpose, and the definitions of various important key terms, which is very, very important before we start with any regulation. First of it being a connected person. Now, I'm sure that all of you are aware of what are the role of SEBI and how important it is in regulating the securities market in today's time. When you talk of a connected person, reading from the bare text, it says any person who is or has during the 6 months prior to the concerned act being associated with a company directly or indirectly in any capacity, including by reason of frequent communication with its officers or by being in any contractual, fiduciary, or employment relationship, or by being a director, officer, or an employee of the company, or holds any position, including a professional or business relationship between himself and the company, whether temporary or permanent, that allows such a person directly or indirectly access to unpublished price sensitive information or is reasonably expected to allow such access. Now let's break this particular point down into various subparts. It is very important to note that if there is any person who is at present or in the past during the prior 6 months of the act that is in question, who has been associated with the company in question, either directly or indirectly, it also is so inclusive that it has added another layer that says that in any capacity, if you have been in frequent communication with any of its officers, which includes its directors, the key managerial personnel, etc., either by way of a contract, a fiduciary position, or an employment relationship. Because as we know, a lot of times, there are certain positions in a company that are not by way of employment. So that also will be included under this particular definition. Or holds any position, including a professional or business relationship between himself and the company. So say, for example, all of us professionals who are here, whether you are a CA, a CS, you're a compliance officer, you're a legal officer, in whatever capacity, even if it is professional or business in nature, if you have any kind of communication with the company, and most important, that you have a direct or indirect access to unpublished price sensitive information, or if there is a reasonable expectation that you have access to this UPSI, then in that case, you will be termed as a connected person. Now, a lot of you must be wondering what is UPSI. Now, we'll be doing that again in the definition section itself. I'll take you through what UPSI also is. But to give you a brief of what it is basically any kind of an information that is not readily available to the general public at large. So if there is any confidential information that is going to heavily affect the securities of that particular company, and this information is only available to a certain special sector of people within the company itself, then in that case, it is known as UPSI. And if any person from the definition that we've already read has access directly or indirectly to this UPSI, he will be considered as a connected person. Now, continuing this definition further, it also says, without prejudice to the generality of the foregoing, the persons following within the following categories shall be deemed to be connected persons unless the contrary is established. Unlike the previous section where we read the definition of who a connected person is, this particular definition is going to give us who a deemed connected person is. Again, one thing that is to be borne in mind is that a deemed connected person can always be rebutted. So if you have any kind of proof that you are not under this definition of a deemed connected person, that can be presented to the courts as well. It says an immediate relative of the connected persons specified in clause 1, or B, a holding company or associate company or subsidiary company, or C, an intermediary as specified in section 12 of the Act, or an employee or director thereof, or D, an investment company, trusting company, asset management company, or an employee or director there, or E, an official of a stock exchange, or F, a member of board of directors of a mutual fund, or a member of the board of directors of the asset management company of a mutual fund, or is an employee thereof, or G, a member of the board of directors or an employee of a public financial institution as defined in section 272 of the Companies Act 2013, or H, an official or an employee of a self-regulatory organization. Recognize, if my voice is breaking, just give me a minute. I'll fix the internet connection. Just give me a minute. Is it better now? Okay, we'll continue. I, a banker of the company, or J, a concerned firm, trust, Hindu undivided family, company, or association of persons wherein a director of a company or his immediate relative or banker of the company has more than 10% of the holding interest. Now, this might seem like a very long, exhaustive list of who could be considered as a deemed person. But one thing that is to be kept in mind is that these are all people who are privy to certain UPSI, unpublished price sensitive information. And by reason to believe of their connection to either the connected persons of the company or to the company itself, they are privy to certain information that the public at large is not privy to. And hence they are deemed to be considered as connected persons. Now, there is a very important note that is specified in the regulation itself. It is intended that a connected person is one who has a connection with the company that is expected to put him in a position of in possession of unpublished price sensitive information. Immediate relatives and other categories of persons specified above are also presumed to be connected persons, but such a presumption is a deeming legal fiction and is rebuttable. This definition is also intended to bring into its ambit persons who may not seemingly occupy any position in a company, but are in regular touch with the company and its officers and are involved in the know-how of the company's operations. It is intended to bring within its ambit those who would have access to or would access unpublished price sensitive information about any company or class of companies by virtue of any connection that would put them in possession of UPSI. Now, if you go to the previous slide, I'll take you through that. If you see, most of the connections here are not direct connections. So if, say, for example, you take the banker of a banker of a company is not someone who's going to be particularly in charge of the company or the securities of the company, but is majorly a person who would have frequent communications with the company, because of which they would be privy to certain UPSI that the general public at large does not have. The official of a stock exchange, for example, or a clearing house, they would have certain information before it is gone out to the public at large, before an official public announcement is made. That is why such an official is also considered to be a deemed connected person. But there could be an official who might not directly be dealing or working at the trading floor, that particular official will not have any kind of information that would be considered as UPSI. Then in that particular situation, he shall be in a position to rebut the entire deemed connected person. Now, with this being understood who a connected person is, we go on to the next definition, which is the definition of an insider, which our regulation is trying to regulate, which is insider trading. So let's understand who an insider is. An insider means any person who is first a connected person or in possession of or having access to unpublished price sensitive information. Now we've already understood who a connected person is. A connected person will also be considered as an insider. Now, if this connected person is a deemed connected person, this presumption can be rebutted and he will not be considered as an insider under this definition. But there is another layer to it. It says that it is also possible that you might not be a connected person, but still have access to UPSI, unpublished price sensitive information. You will still be considered as an insider. Let's read this note and then understand in detail what is UPSI. Note, since generally available information is defined, it is intended that anyone in possession of or having access to UPSI should be considered an insider, regardless of how one came in possession of or had access to such information. Various circumstances are provided for such a person to demonstrate that he has not indulged in insider trading. Therefore, this definition is intended to bring within its reach any person who is in receipt of or has access to UPSI. The onus of showing that a certain person was in possession of or had access to unpublished price-sensitive information at the time of trading would therefore be on the person leveling the charge, after which the person who has traded when in possession of or having access to UPSI may demonstrate that he was not in such possession or that he has not traded or he could not access or that his trading when in possession of such information was squarely covered by exonerating circumstance. Now, if we are to understand this particular note, it says that generally available information is nothing but information that is put out by the company itself for the public at large. And when anyone is in possession of such unpublished price-sensitive information that has not yet been generally available, then in that case, the person so trading the securities during this period will be considered as an insider, irrespective of how he has come in possession of such information. So we'll take a hypothetical situation. The situation is that one of the promoters of the company has just gotten access to your quarterly finances. And these quarterly finances are not yet made generally available to either the stock exchange, to SEBI, or to the shareholders of this company. Now, this information, because it has the capability of affecting the market in such a way that it can fluctuate the share prices, this information is considered as unpublished price sensitive information. And if this information is used to trade on any platform, shares either to make profit or to avoid losses, you will be considered as an insider. Now, it could also so happen that I am not someone who is working for the company. I have no direct access to the promoters of the company. I have no access to the auditors of the company. But somehow, through any platform, I have gotten access to this UPSI, unpublished price sensitive information. I will be considered as an insider. There is a particular case of WhatsApp that we'll be doing at the very end, which actually demonstrates how insider trading by non-connected persons has also led to SEBI taking cognizance. So if there are investors who have received such tips or have received such UPSI through any form. It could be through SMSs, it could be through Facebook, it could be through Telegram, it could be through any means whatsoever, irrespective of you knowing who the connected person is or who has given you this information. If you trade using such information, you will be considered as an insider under this regulation. Now, it is also very important to understand that the onus is on the person trading while in access of UPSI to prove that he has not traded based on this information that was provided to him. So the person leveling the charge will only have to show prima facie that the person is an insider, and the rest of it, proving that you are not an insider and have not traded based on access to UPSI, will be completely on the defendant to decide. Now, we go on to the definition of UPSI under our regulation. Unpublished price-sensitive information means any information related to a company or its securities, directly or indirectly, that is not generally available, which upon becoming generally available is likely to materially affect the price of the securities and shall ordinarily include but not restricted to information related to the following. First, financial results. Second, dividends. Third, change in capital structure. Fourth, mergers, demergers, acquisitions, delisting, disposals, and expansion of business and such other transactions. Fifth, change in key managerial personnel. Now, if we have to break this up into various parts, let's first start with any information that is related to a company or its securities. Now, if we are to understand the definition of company is already provided under the Companies Act 2013, securities is defined under SERA. And SERA, the definition of securities is quite inclusive in nature. So it goes on to say that your shares, your debentures, convertible debentures, all of these will be considered as securities. So if you have any kind of a characteristic of a new financial instrument that has the characteristic of a security, it will still come under the definition of securities under SERA. So which means it's a very, very inclusive definition. So any information related to the company or any of its securities, whether directly or indirectly, which is not generally available, is considered as unpublished price-sensitive information. Now, what is also important, there's another layer to this, which is also important, that this information, if at all, is made generally available to the public, it is likely that it will materially affect the price of that particular security. So any information having the potential of affecting the price of the security shall be considered as UPSI. Now, what these regulations have done is they have given an exhaustive list, but it is not restricted to this itself. It says the financial results, the dividends that are announced, change in the capital structure, then your mergers, demergers, which are your corporate restructuring, and changes in either the directorship or the chairmanship of the company. All of these are considered as UPSI. Now, I will give you an illustration. Recently, the chairman of Tata Sons passed away, Mr. Ratan Tata. So let's take a hypothetical situation where Mr. Ratan Tata might have passed away in the morning, and the information was made public in the afternoon by the company. The time duration between him actually passing away and the time by which this information was made public, generally available to the public officially by the company, between this particular time, this information remains UPSI, unpublished price-sensitive information. The reason for this is the change in the managerial position of a company and at a designation such as the chairman of the company is likely to cause a stir in the market and will fluctuate the prices of the securities that are listed. So hence, this particular time period is considered sensitive, and any kinds of dealings done by people who were aware of this information during this particular time will be considered as insider trading, and this information shall be considered as unpublished price sensitive information. Now, another thing that is important to note is if you are having general discussions, if say there are two companies that are going for a merger, and if there are only primary level discussions that are happening between the board of directors of both these companies, that will not be considered as UPSI. It is only when this particular agreement is going to conclude and it has been decided that you are going to go for a merger and it has not yet been made public by any form, then in that case, it shall be considered as UPSI. Now, change in capital structure will also include, say, delisting of your shares from the company, buyback of shares, your, say, giving an exit option to minority shareholders. These are all considered as change in capital structure, and that will also be considered as UPSI. Now, let's read the note. It is intended that information relating to a company or securities that is not generally available would be unpublished price sensitive information if it is likely to materially affect the price upon coming into the public domain. The types of matters that would ordinarily give rise to UPSI have been listed above to give illustrative guidance on what UPSI is. Apart from that, also, if at all SEBI feels that there is any information that was used at that time, which, if made available publicly, would likely materially affect the price of the securities, SEBI can also deem that as UPSI. Now, let's go into what the role of SEBI is in this entire process of identification of insider trading. Now, let's first understand that what is wrong with insider trading. We've understood what who a connected person is. We've understood what UPSI is. We've understood who an insider is. Now, let's understand what is the problem that we are facing and then go on to the role of SEBI. What happens is that there are certain people who have access to this confidential information of the company. Because it is not illegal for the people who are privy to such confidential information to also trade their securities of the same company. Sometimes it puts them at an unfair advantage where people having access to this information are going to go and trade their shares either ways, either buy the shares or sell off their shares in the stock market to avoid losses or to get profits. So say, for example, if the company is going into a loss, this information is only available to the auditors and the board of directors. Board of directors, auditors, and the relatives of the auditors are put at an unfair advantage where they are going to sell off their shares before the general public does. And by the time they do that, the kind of loss that they are going to incur is going to be usually lesser than what the retail investors would incur. And to not give an unfair advantage to people who are privy to such information, you have your insider trading regulations. And this is where SEBI steps in. The main purpose of SEBI and the role of SEBI is investor protection. And when it comes to investor protection, it is not just protecting a small chunk of investors. It is retail investors at large. And whenever there is insider trading, a lot of times it is the retail investors that lose out on most of the value of the share, because people who are capable of taking that hit, people who are in a position to actually reduce the losses or increase the profits in that manner, have not done this job, and to give them an unfair advantage over the people who have laid their trust in them is against the objectives of SEBI. So let's go into the role of SEBI. First role is regulation and framework, where SEBI has put in place robust regulations to curb insider trading, most notably the Prohibition of Insider Trading Regulations 2015. Now, this particular regulation provides, it clearly defines what constitutes insider trading and who qualifies as an insider. It mandates companies to have internal codes of conduct to monitor and report trading by employees and connected persons. Establish the principle of Chinese wall to prevent the flow of UPSI within organizations. Now, the last 2 points are very, very important. I'll tell you this in brief, and as we go further, there are other slides also that where we'll be discussing this in detail. So what SEBI has mandated is that there is something known as internal code of conduct that has to be established by the company itself. Here, there will be a compliance officer who will ensure that there is a digital list that is maintained as to who has access to UPSI. When was it last accessed, which is a digital footprint that is maintained, so that you are able to track that who was the last person who had access to this information and where could that leak have incurred. So this is a very interesting step that is taken by SEBI. And the next is the principle of Chinese wall. So Chinese wall is basically where there are different departments in a company. And it is encouraged by SEBI that these departments are, there are these virtual walls that are created so that information does not transfer from one department to another department. So say, for example, if the audit committee is privy to certain information, that information should be barred by a Chinese wall, a virtual wall that restricts the flow of information from the audit committee to the trading committee and from the trading committee to the sales department. These are various departments that have to be bifurcated so that information or important information does not spread within the company, which makes it difficult to actually track where the information leak has incurred from. Next is surveillance and detection. SEBI employs advanced tools like integrated market surveillance system to monitor unusual trading patterns, particularly around sensitive corporate announcements. Using big data analytics and AI-driven algorithms, SEBI can identify suspicious trades that may indicate insider trading. So to give an example, you say a company has recently just announced its quarterly finances. And right before these finances were declared, there were major trades that have taken place by certain directors of that particular company. Now, in this situation, AI can be utilized to actually check whether the timeline, what is the timeline between the announcement of this UPSI to the general public and that particular trade that has happened. Say the company was going to go into a loss and that is supposed to be declared in the investors meeting. And right before that, all the important people or all the connected people or all the insiders of that company have sold off a major chunk of their shares. It is it can be identified that these people have indulged in insider trading. Then comes the investigation process. When suspicion arises, SEBI launches detailed investigations. These include scrutinizing trading data, communication logs, and financial transactions, identifying individuals or groups with access to sensitive information, connecting the dots between the leak of UPSI and abnormal trading activities. Now, here again, like I told you, you have something known as a compliance officer. This compliance officer is going to maintain a digital database where you're going to log in every time an insider has had access to UPSI. Now, this along with the communication logs. Now, communication logs could be your WhatsApp messages. It could be your phone conversations. All of these are then tracked during the investigation process to ensure that right after you had access to UPSI, you have not communicated this important information to someone outside of the company. Now, like we already discussed in the definition section, even if you are not an insider, you are not a connected person, you are not a director, you are not an employee, but you still have access to UPSI, you shall be considered as an insider under these regulations, and you will be penalized if at all you are found trading while having access to UPSI. Then let's come to the next, which is enforcement and penalties. SEBI has strong enforcement powers, and its penalties for insider trading are substantial. Guilty parties may face fines up to 25 crores or 3 times the profits made, whichever is higher. Bans from securities market, sometimes for years. Confiscation of illicit profits through disgorgement orders. Criminal action in coordination with law enforcement agencies. Now, if we are to see the first one, which is fine up to 25 crores or 3 times the profits made, it is basically if I have traded and if I have made certain profits having access to UPSI, that particular chunk of money that I have made by utilizing UPSI will be considered as my profit. And 3 times the profit will have to be paid as a penalty. Now, also a lot of times there are you have avoided a loss. So say had I not traded while in access of UPSI, I would have made a loss of say 10 crore rupees. That particular loss of 10 crores that I avoided by trading, having access to UPSI shall be considered as my profit in cases of this particular uh, enforcement and penalties. Next would be education and prevention. SEBI also emphasizes awareness and training for market participants by encouraging compliance through education. SEBI ensures a culture of ethical trading. In recent years, SEBI has further strengthened its mechanisms. It now monitors digital communication such as WhatsApp messages to track leaks of UPSI. Enhanced whistleblower frameworks have been implemented to encourage reporting. SEBI is leveraging blockchain and AI tools for better surveillance and enforcement. Now, one very important thing that we need to discuss also is there a difference between the responsibilities of an insider and a connected person? Like we saw that all connected persons are insiders, but there could be times when there's a connected person who is not in access to UPSI. What would be the difference between the two? And what would be the responsibilities of both? Now, this particular slide is just talking about a brief of what we've already discussed, which is a definition section of connected person, deemed connected person, and an insider. Now, what we quickly come to is the key features. So unlike a connected person, an insider can include individuals who may have no formal or direct connection with company but still has access to UPSI. Now, a connected person, like we already saw in the definitions clause, is someone who has frequent communications. Either you are a director, you are someone who's associated, you are an employee, or you have any kind of a business relationship with the company. You can also be indirectly or connected, or you could be a deemed connected person, but you need to have some kind of a relationship with the company or one of the connected persons. Unlike that, an insider can include anyone who has no connection but still has access to UPSI. So today, like the information or like the example that I gave you previously, if I have received certain information through WhatsApp messages, irrespective of me knowing or not knowing the key managerial personnel of the company, I will still be considered as an insider. The burden of proving that they did not misuse the UPSI lies with the insider. What is the key difference? Connected persons are defined based on their association or relationship with the company, which gives them a reasonable expectation of having access to UPSI. Insider encompasses a wide group, including connected persons and any individual in possession of UPSI, irrespective of their connection or relationship with the company. This is the major distinction between the two. I could have zero communication with the director of the company, but I still have access to UPSI, which makes me an insider and vice versa. Then, what are the responsibilities of an insider? Because here, when we discuss about insider trading or any kind of prohibition, it is not prohibiting a connected person. It is not saying that a connected person is always an insider. A connected person may not even be an insider. So let's see what are the responsibilities of an insider. Avoid trading while in possession of UPSI. Like I've already discussed previously, that if you have access to UPSI, you have to avoid trading during that period. From the time you have received this UPSI till the time this UPSI is made generally available by the company. During this period, it is a sensitive period and you are not allowed, you're not permitted to trade during this particular time period. But there are two exceptions to it. The first exception is that the trade was conducted without the knowledge of UPSI. And second is that there is a pre-approved trading plan under your regulation size. Now, say for example, the trade was conducted and you had no idea that there is such an information. Then in that case, this trade will be considered as a valid trade. So say there is one of the directors and the relatives are there. The director has zero contact with the relative for 10-15 days. And during this 10-15 days, before the UPSI has actually been communicated to the immediate relative, the relative has gone ahead and has traded his share. This shall not be considered and it will be exempted because the relative was not in knowledge of the UPSI. Second is a pre-approved trading plan. Now, trading plan is something that we'll be doing elaborately in the further sections. So a pre-approved trading plan is something that we'll be doing in the further sections. I'll just take your question very quickly. So can he trade in securities other than a specified company? Absolutely so. So say for example, today there's company A, of which I have UPSI, unpublished price sensitive information. If I'm using this information to trade in this company, the company whose information I have, I will be considered as an insider. But if this company has nothing to do with the other company, in which say company B, in which I want to actually trade, then in that case, I trade with that company. That will not. Have I answered your question, sir? So he's given out this information, this UPSI, bit of a connected person, but you have disclosed this UPSI in order to make a trade. That will be considered illegal and it will also come under your regulation 3 where you're not supposed to be disclosing UPSI to other people. Next comes adherence to trading plans. Now, trading plan, if it is already approved by the compliance officer, it cannot be modified or deviated once it is approved. Now, trading plan is nothing but it is an entire 18-month plan. The maximum time period where you can actually make your trading plan is for 18 months. What happens in this is that a lot of times there will be people within the company that will have perpetual access to UPSI. By perpetual access, I mean that today there is one event that has taken place, tomorrow there will be something else, and the after there will be something else, and all of that are likely to affect the securities market. Based on this, they will never be able to trade because they are perpetually in possession of UPSI. There will also be their immediate relatives who will never be able to trade. So, in order for them to be exempted from the responsibility of insider trading, SEBI has actually provided them an exemption where they can provide a trading plan where they are in advance. They are providing when are they going to purchase certain securities, when are they going to sell certain securities of that particular company. And this plan is provided to the compliance officer, who is then going to approve this trading plan. There will be a cooling off period of 6 months so that during the plan that you have presented, you are not in possession of any UPSI. And even if you are in possession of UPSI, that has become stale by the time your trading plan is implemented. So you can make a maximum plan of 18 months with a 6-month cooling off period. And during this tenure, if there is any trade that you have executed, even though you are in possession of UPSI, you shall be exempted and you will not fall under the definition of an insider. The only thing that has to be taken care of is that once a trading plan is prepared, once a trading plan is approved by the compliance officer, it cannot be modified or revoked. So today, if you feel that there's going to be a major loss to the company, and if you have decided to buy some amount of shares in the near future according to your trading plan, you cannot cancel this. You will have to go ahead and you will have to execute your plan. So even if it is going against your plan, you will still have to abide. Next is maintenance of confidentiality. UPSI, as the name suggests, is highly confidential. So you cannot be disclosing this information to people who are not supposed to be in possession of this information. So except for your legal officers, your auditors, it is not necessary for you to actually be disclosing this information. And hence, confidentiality has to be maintained. Then disclosure of trades. Now, once there is any trading plan that has taken place, you need not disclose your trades regularly because it has already been approved by the compliance officer. But say, for example, there is any immediate relative who has traded, or there are any trades above specified thresholds by your company itself. You have to notify this to your compliance officer and to SEBI within 2 trading days. So that in case if there is any chances of an insider trading that has happened, then in that case, it becomes easier for SEBI to actually pinpoint those people and see where the leak had actually started from. So in good faith, everyone who is an immediate relative or has traded above a specific threshold must disclose their trades. Proving innocence. In case of allegations, the insider must demonstrate that they have not misused UPSI and violated the regulations, which is quite self-explanatory. Then we come to the next, which is responsibilities of a connected person. Now, we've already discussed what is the responsibility of an insider. And we've seen what is the difference between both an insider and a connected person. Let's talk about the responsibilities of a connected person. First, prevention of insider trading. The presumption always is that a connected person has access to UPSI. And that is why they should be prevented from trading while in possession of UPSI for personal gain, unless it is for legitimate purposes, which includes your pre-approved trading plans. Disclosure of trades. They, like we already discussed in your insider responsibilities of an insider, you need to disclose your trades. Adherence to code of conduct that has been specified by SEBI itself. Maintenance of confidentiality and burden of proof, which remains the same in case of a connected person. Yes. So let's go ahead to understanding what unpublished price sensitive information is. We've already seen the definition. Now let's delve a little into what is the importance of UPSI. UPSI includes any material information about a company that is not publicly available but could impact investor decisions. It is crucial to safeguard UPSI to prevent its misuse and ensure fair trading practices in the securities market. By strictly regulating the disclosures and handling of UPSI, SEBI aims to maintain the integrity of financial markets and protect the interest of all investors. This is something that we've already discussed. I would love for anyone to have any questions and put it in the chat box so that we can, be addressing it alongside. So if anyone has any questions related to UPSI, you can put it in the chat box. Right. So let's go into discussing various forms of UPSI. Like we've already discussed that the regulation is quite elaborate in nature and it has given an illustration of what all could constitute as UPSI. But let's discuss that in detail. First being financial results. Information related to company's financial performance before its official disclosure can significantly influence the stock prices. Example, quarterly earnings reports indicating a profit or a loss, annual financial statements revealing significant changes in the revenue or profitability, adjustments or restatements of previously reported financial results. This is quite self-explanatory. If anyone has any questions, I would love to take that. Let's move on to dividends. The declaration or non-declaration of dividends is a key indicator of a company's financial health. Example, declaration of interim or final dividends, a significant change in dividend payout policy, a special one-time dividend announcement. This will also be considered as UPSI. Any questions here? Right. Changes in capital structure, as we've already discussed, if there's an IPO, if there's an FPO, or if you're going for a rights issue, if there's a stock split, if there's a reverse split, there's buyback of shares, conversion of debentures or bonds into equity, all of these will be considered as changes in capital structure, which is included as part of UPSI. Then the fourth point will be all your corporate restructuring. So mergers, acquisitions, say a demerger, sale of an asset, joint venture, strategic partnership, all of these are also considered as UPSI. Changes in key managerial personnel, KMPs, again, appointment, resignation, removal, sudden death, retirement, major reshuffling, all of these are considered as part of UPSI. Any material change or any material event or business expansion. So if you are expanding into a new market, new geography, you are increasing your domain to a new product or a service, closing an old operational facility, all of this will be considered as a material event. To give an example, our Geo Hotstar, for example, when that was announced, that is a major expansion into a new horizon, a new product market. When this happens, this will most certainly cause a stir in the market, in the securities market, and hence affect the share prices of the company. So this is considered as a material event. But say, for example, if there are smaller events that take place on a day-to-day basis, that shall not be considered so material to be considered as UPSI. Then delisting or suspension of securities, say if SEBI has imposed any kind of penalty on the company, or if there's a voluntary delisting of a company, or if you've been suspended from trading due to any reasons, it has to be made public before you are able to trade. Corporate defaults or bankruptcies, again, non-payment of loans is something that is always hidden by these companies because it will most certainly affect negatively in not and not in favor of the company, and hence it is considered as UPSI. Regulatory approvals or actions. If there is any kind of an approval or a rejection of license, or if it is pending, or if there are fines that are imposed, if there are sanctions that are imposed, these are all considered UPSI. The 10th point will be any legal cases that have been initiated, arbitration matters, high profile lawsuits. Like we recently saw that there was a Tata Mystery dispute that had happened, in which there was the Tata Sons versus Mrs. Cyrus Mystery. Again, that was a high profile lawsuit. If it is not made publicly available, again, it will be considered as UPSI. There's a question whether changes in unquoted subsidiary needs to be reported. Changes in unquoted subsidiary, as in, can you please elaborate on your question? Or you're trying to say an unlisted subsidiary? We will take that question once you rephrase it. Right now, let's discuss about key characteristics of UPSI. The first is non in nature. UPSI by definition refers to information. Definition refers to information that is not generally available to the public. Information becomes generally available only when it is disseminated to the public on a non-discriminatory basis. Now, the major characteristic of a UPSI that it has to be told to the public in a non-discriminatory basis. So, say for example, today I have my shareholders of a company. I have my UPSI. I go to the shareholders of my company and just inform them, saying that today we have incurred huge losses, and that is only declared to a specific set of shareholders. This will be considered as discriminatory basis disclosure of information and will still be considered as UPSI. So, how can a non-discriminatory basis disclosure be made? First, information should be published on the stock exchanges. Second, there is a press release issued to the public. Third, updated on the company's official website. It is made in such a manner that you are not able to identify whether you're making it to a specific set of people or you're making it to the general public at large. If it is only made to the shareholders and if it is only meant for their eyes, it is still considered as. So you need to make it in a way that it is generally available to the people at large. Second characteristic is potential to materially impact the stock price. Like we've already discussed, if this information is so crucial that there is a potential of fluctuation in the stock prices, then in that case, it will be considered as a UPSI. Now, what also has to be known is that it is not necessary that the stock price have to actually fluctuate, but there should be a potential or there should be a perceived risk that the company's security prices will fluctuate. Then it will be considered as UPSI. Again, UPSI is not just limited to financial data. It can be, there can be a plethora of things that can be included. So all your events, your business expansions, your mergers, changes in key managerial personnel, etc. Everything will be considered as part of UPSI. Again, the fourth point is it is subjective in nature. So you cannot have a definite list of things that will be considered as UPSI. Depending on the situation in hand, such information shall be considered as UPSI. So it depends on a case-to-case basis. Okay, so there's a question from one of our guests. They've said whether changes in unlisted subsidiary need to be reported. Changes refer to what is applicable to its holding company. Now, so one thing that you have to remember is if there's a holding company, they have a substantial control over its subsidiary company. And when there's a substantial control over the subsidiary company, it is most likely that they are sharing their managerial personnel. And when that happens, it is obligatory on your part to actually make certain disclosures to either your parent company or to your subsidiary company. So if at all, say for example, the parent company has not disclosed certain information to its subsidiary company, it will still be considered as a UPSI for them. But if the subsidiary company top management is also aware of this information, they too will be considered as insiders for purposes of trading in the parent company. Is this clear? So, and another information that I would like to give you, if there's any kind of a material change in the holding company, which is a parent company, that particular change, if it is likely to affect changes in the stock prices of the subsidiary company, that information shall also be considered as UPSI. So, like I gave you the example that if Mr. Ratan Tata was there, now if Mr. Ratan Tata's death would affect the share prices of subsidiary companies of Tata Sons, it will be considered as UPSI for its subsidiary companies also. Have I answered your question, sir? Yeah, I'll give you another example in this regard. Say, for example, there's a joint venture between two companies, right? Out of these two companies, if one of the companies is going through a financial difficulty, there's a financial loss. If this particular financial loss, this information is made public, the other company, which is not going into a loss, but is in a joint venture with this loss-making company, that company's share prices will also be affected. In this situation, the information of company A will be considered as UPSI for company B as well. Right? Yes. Let's quickly move on to handling and disclosure of UPSI. The first point is that there has to be legitimate sharing of UPSI. UPSI is highly confidential, and hence you cannot be sharing it with every second person. Only if it is necessary for you to share that information for legal purposes, only then is it necessary for you to share it. I'll give you an example. So, say you're doing it in ordinary course of business, you're sharing it with your partners, you're sharing it with your legal advisors, merchant bankers, auditors, insolvency professionals, or consultants. During your mergers negotiation, this information is important only then. You should not be going out and divulging this very, very confidential information to other people. Prohibition. UPSI cannot be shared to invade the prohibitions of insider trading regulations. Sharing UPSI for speculative or personal gain is strictly forbidden. Second, structured digital database. To maintain transparency and traceability, companies are required to maintain a structured digital database. Now, this is important. The key features of the database is the details of the nature of UPSI that is shared, names and identifiers of the individuals with whom UPSI is shared, time-stamped records for access and sharing, internal controls to ensure that the database is tamper-proof. Now, what this is basically trying to say is, sorry. Just give me a minute, please. Yeah. So what this is trying to say is that you need to have a digital database that is going to ensure that every person who is in access of this UPSI is identified. So if you have your PAN card details, you have your Aadhaar card details, you have your DIN, which is your director's identification number, all of these details are shared. So whenever that particular individual is trying to access this UPSI, the data is stored and is time-stamped to ensure at what time was the data collected from this database. The reason why this is done is so that if at all there is a breach, you are able to identify that when was the last time that a particular individual had access to this UPSI, and from that time till that time where all that data was shared. Now, another very important thing in the digital databases that this database must be preserved for a minimum period of 8 years. And if at all there is any investigation or legal proceedings, it must be retained until the completion of such proceedings. Any questions in digital database? Now, next is confidentiality of UPSI. UPSI must be handled with utmost confidentiality to prevent unauthorized access or leakage. The best practices are Chinese wall that we have already discussed. Chinese wall is nothing but establishing barriers between various departments that need not be in conversation about UPSI. So you are separating the mergers and amalgamations team from the trading desk because it is not important for the two of these departments to be having any kind of conversation related to UPSI. Limited access. UPSI should only be shared on a need to know basis. So if there is a person who need not have any access to this information, if it is not a financial information, the auditors need to have this information, then why give it to the auditors? So only if there is a requirement for that information to be disclosed to the person, should it be divulged. Confidentiality agreements. You should always have an NDA in place with whoever you are sharing your UPSI. There should be a code of fair disclosure as per the requirements. It should cover your timely and of UPSI, universal and uniform dissemination of information, which is making the information available to the general public at large. Prevention of selective disclosure. Now, again, very important is public disclosure of UPSI. How is it going to go ahead? When a company decides to disclose UPSI, it must ensure that the information is made publicly available in a non-discriminatory manner. Now, what are the various modes of disclosure? First will be filing with the stock exchanges. Second is press release or investor presentation. Third, a official website. These are few of the methods through which you can disclose UPSI. Now, what should be the timing? UPSI must be disclosed to the public before the insiders or connected persons can trade in the company's securities. So say, for example, if there is any trade that is going to take place, before the insiders can actually trade, UPSI should be disclosed. The exception to this is, in certain cases, UPSI may be shared selectively for legitimate purposes, but the recipient must be treated as an insider and adhere to confidentiality. This is self-explanatory in nature. Now, whistleblowing mechanisms. SEBI also has provisions for whistleblowers to report the misuse of UPSI. Again, they are provided protection against retaliation, termination, harassment. Confidentiality is maintained, and he's also eligible for monetary rewards that are provided by SEBI for being a whistle. Now, what are the prohibitions on trading while in possession of UPSI? We've discussed a lot of it, but let's just quickly go through it once, if at all you have any doubts. First is prohibition general prohibition. Insiders, which are persons with access to UPSI, are prohibited from trading in securities of a company if they are in possession of UPSI at the time of the trade. The rationale is to prevent individuals from using confidential, non-public information to gain an unfair advantage or profit in securities trading. The exception to the prohibition is a pre-approved trading plan, which we've already discussed, demonstrating non-use of UPSI, and the burden of proof is always with the insider to prove that he was not in access of UPSI. If anyone has any questions, I would be willing to take those also. You can put it down in the chat box. Next is your trading plan in your regulation 5 of your insider trading regulations. The key features are pre-approved by the compliance officer. The trading plan must be submitted to the company's compliance officer for review and approval. The compliance officer will ensure that the plan does not violate insider trading regulations. This particular plan, once it is approved, will be disclosed publicly through the stock exchanges where the securities are listed. And due to this entire disclosure, this is ensuring transparency and eliminates any perception of unfair advantage. Then there is a cooling off period. Now, this cooling off period is for at least 6 months. This is to ensure that during the time of approval of the trading plan and execution of the trading plan, there is no UPSI that is in possession of the insider. And if at all there is any kind of a UPSI, it becomes stale or irrelevant by the time that you are going to start trading according to your plan. This particular trading plan, like we already discussed, is irrevocable. Once it is prepared, it cannot be revoked in order to misuse or have selective trading. The minimum duration of the plan is at least 12 months and maximum is 18 months with a 6-month cooling off period. There cannot be overlapping plans or there cannot be plans that are ambiguous in the timeline that has been specified. The details of the trading plan must specify the number or value of securities, nature of the trade, which is either you are buying or selling the shares, the specific dates or time intervals when the trade will occur. Again, no trading during sensitive periods. There are certain periods that are sensitive in general, which include 20 days prior to the end of a financial period that is basically sensitive to all companies. 2 trading days after the disclosure of financial results. These are considered as blackout periods to ensure that the traders are not executing it at the time of high market sensitivity. Now let's come to the role of compliance officer and code of conduct. Now, compliance officer is appointed by a company, and his role is firstly to develop policies and implement this policy with regards to insider trading regulations. Second is to monitor insider trading activities, including the insiders, connected persons, and designated employees. And if there is any kind of suspicious pattern that is detected, he should bring this to the notice of SEBI. This person will also be responsible for approving trading plans like we've already discussed and also handle UPSI. So if there is any UPSI that will be made public to certain connected persons, the nature of the UPSI, the names of the individuals, the stamped logs, all of these are supposed to be in possession of the compliance officer. And this database will be monitored by the compliance officer. Pre-clearance of the trade. So if there are any insiders or designated employees who require pre-clearance for executing the trades, the compliance officer has a responsibility of doing so. Then training and awareness within the company itself to explain the code of conduct to the employees, to the management, to the connected person. Then investigating violations. If there's any kind of a violation or if the whistleblower has reported any kind of malpractice, it is a responsibility of the compliance officer at the first stage to take it up and then inform it to the board along with SEBI. Coordination with the regulatory authorities, if at all SEBI and the stock exchanges are asking for any information, it is a compliance is basically prepared by the compliance officer. It includes protection of UPSI, need to know principle, confidentiality protocols, along with trading window restrictions, like we have discussed, 20 days before the end of a financial period and 2 days after the announcement of financial results, you cannot be trading. So these trading windows are restricted during that period. Pre-clearance of trades, trading plans, and whistleblowing mechanisms. Now, what are the methods that are used by SEBI to detect insider trading? First is that SEBI uses advanced surveillance mechanisms to actually check across various stock exchanges whether there is any kind of trade that has happened while in possession of UPSI and before making that UPSI a generally available information. And using these algorithms and artificial intelligence, SEBI can identify certain leaks. Now, pattern analysis, which means that if there is a sudden market activity near a corporate announcement, such as a merger or a dividend declaration, then in that case, SEBI can investigate it. Monitoring key individuals. Now, there are certain people who are identified as key managerial personnel who will be in possession of UPSI perpetually. They are people who cannot avoid individuals, or these key managerial personnel are monitored continuously by SEBI. Whistleblowing mechanisms, we've already discussed, and tracking of UPSI leaks. Now, one of the major cases in this situation for tracking the leaks is the WhatsApp case. But before that, there's just a question that I believe someone has. I'll take this question first. Yes, it says, when a closure window is declared by a company, can I buy or sell shares? Does it lead to insider trading? No, dear. So if you are not an insider, if you are not a connected person, you are just a regular retail investor, for you, this particular window is not applicable. This window is only applicable to ensure that there are certain insiders who are not trading during this period. And if you are not an insider to that company, you are exempted from this insider trading regulation. Right? Yes. Let's quickly come to the WhatsApp leak case. Now, what had happened? Let's go into the brief background first. The WhatsApp leak case of 2007 is one of India's most significant insider trading investigations. It highlighted the role of technology in insider trading and SEBI's commitment to addressing the misuse of UPSI. The case involved unauthorized sharing of sensitive financial data through WhatsApp groups before. Now, just to give you a brief of what had happened, a lot of us are also in these WhatsApp groups where they give us tips. You know, there are these stock analysts and brokers who give us tips. You know, this particular share is going to increase because of so and so reason, and I believe that you should either buy the shares or you should sell the share. This is what had happened in the WhatsApp leak. That there was certain unpublished price sensitive information, UPSI, that was leaked through WhatsApp groups. And because WhatsApp is a digital market, there was no connection as to what happened to that UPSI and how many people had access to it because it was on a technological platform. The background of the case was that in November 2017, media reports revealed that sensitive financial results of several prominent companies such as Axis Bank, HDFC, and Wipro were circulated on WhatsApp before being officially announced. These messages included precise details of quarterly earning figures, profit margins, and revenue projections. The leaked information was highly specific and closely matched the company's eventful official disclosures to stock exchanges. The messages were shared across private WhatsApp groups comprising of traders, brokers, analysts, and other market participants. After this, the SEBI investigated into the leak of UPSI under the Prohibition of Insider Trading regulations. The regulator aimed to trace the origin of the leaks, identifying the individuals involved, and determine the insider trading that had occurred. SEBI analyzed the content of WhatsApp messages and compared it with the financial results officially declared by the company. The forensic audits were conducted to trace the flow of information within the company and among market participants. SEBI used advanced digital forensic tools to analyze electronic devices, email records, and messaging apps. Structured digital database maintained by the companies were examined to determine who had access to UPSI and whether proper controls were in place. The SEBI also questioned brokers, analysts, employees of listed companies, and other connected persons who trace the chain of information that was shared. Yes. It was found eventually by SEBI that the financial results of at least 12 companies, including Tata Motors, Ambuja Cements, and Mindtree, were leaked on WhatsApp. In some cases, the leaked numbers were accurately or marginally different from the officially declared figures. Many companies failed to maintain proper records of who accessed UPSI. In some cases, UPSI was shared informally within the organizations or with external advisors, leading to untraceable leaks. Lead information spread by rapidly through WhatsApp groups, making it challenging to pinpoint the original source. So, if I have to give you a brief of this case, it is basically nothing but all these stockbrokers who give the predictions on Telegram, on WhatsApp, and eventually it was found out that it was not a bluff. One of these groups actually shared vital information that was not made available to the public. And this information, because it was shared informally with the connected persons to the people who were outsiders, and then they shared it on WhatsApp, it was very difficult to actually maintain a digital database of where the leak started from, who eventually had access to it, and who traded based on this internal information. That is why it was not able to be traced. The actions that were taken by SEBI were SEBI imposed penalties on individuals and entities, brokers and traders who were guilty were fined. Stricter adherence to insider trading regulations, including maintenance of digital database, which is very important, has been implemented by SEBI. Listed companies are directed to enhance their internal controls and code of conduct. SEBI emphasized the rule of whistleblower mechanisms to report insider trading violations. With this, I would like to take any question that anyone might have in the comment section below. And I would be happy to answer any of those questions also. Yeah, there are a few questions. We'll take it here. Someone has written, what if I send an insider information to someone else through a pigeon? Now, as funny as this sounds, if SEBI is able to track this pigeon, most certainly you will be charged of insider trading. But again, this is exactly what happens. I'll give you a case. So what happened in the US? There were two people who were school friends. These school friends eventually went ahead to become CEOs of two major companies. On the face of it, they portrayed that for the last 20 years, they have not been friends with each other. They have not been in communication with each other. It is after 20 years that it was found out that both these people were childhood friends and they were communicating through other methods. Right after the board meeting of one company got over, the secretary of that CEO would call up the fiance of the secretary of the other CEO to give an insider tip. It is after an exhaustive investigation of 10 years was it found out that there was this insider trading going on. On the face of it, they were not friends. They did not contact each other. They had zero communication with each other. And still they were held liable for insider trading. So yes, if someone were to send insider information through a pigeon, it will be considered as insider trading. Someone else has a question. Trading plan cool off period is of 120 calendar days. Yes, absolutely. So it also depends on the regulation that you are following. So say, for example, if you have your own code of conduct, you can always have it changed. When closure window is announced by a company, can I buy or sell shares if it comes, does it come under insider trading? If the closure window is announced by the company, if I am not an insider of the company, most certainly I can trade. If I am an insider of the company having access to UPSI, I cannot trade. Someone else has a question. Does SEBI also track dark web? What if I send insider information to someone using the same? Yes, dark web can be always investigated, but till the time it is not investigated, even if you are sending information through the dark web, it will be considered as insider trading. Whether any material information of unlisted subsidiary company having impact on the results of holding listed company be treated as UPSI. Yes, if there's any information related to unlisted subsidiary company that has not yet been made public, if it is still available only with a certain section of people, if it is likely to affect the market value of the shares of the holding listed company, it is considered as UPSI. Someone has a question. Does SEBI track WhatsApp messages? Isn't WhatsApp end-to-end encrypted? Yes, WhatsApp is end-to-end encrypted. It is not that they are surveillancing WhatsApp. It is if they receive a tip. So say, for example, if I'm a part of that WhatsApp group, and if I have received this information, and if I happen to disclose this to SEBI, they will be able to investigate it further. Is it not a violation of Article 21 right to privacy? No, it will not be a violation of Article 21 right to privacy because there are certain restrictions. Article 21 is not absolute. So if it is in the interest of public at large, most certainly your Article 21 can be violated. Right? If anyone else has any other questions, I would be happy to take those. Thank you, Mr. Abhishek. My contact details are here. If anyone has any questions related to the session, you can send me an email or you can contact me on my WhatsApp number. That's absolutely fine.